Okay, I'll introduce you to the masters here, Professor Lihong Zhang from the University of Shanghai, namely East China University of Political Science and Law. One interesting feature of this university is that they have 12,000 law students, 12,000, which is a number we're not acquainted with usually. The subject of this talk will be codification of civil law in China. Our professor will talk for an hour or a little less, and then a debate will follow. Okay?
Thank you for the recording. It's my great pleasure to stay here and talk to you about codification of civil law in China. I'm a professor of Roman law, comparative law, and civil law. I completed my PhD study in Italy about 10 years ago in La Sapienza University. Essentially, I'm a Romanist. I know Latin, English, French, Spanish, German. So if I have some questions, speak also German, also non-English or Chinese, of course, if you want. And why I choose this subject as a topic? Because I think the codification now in Europe is called harmonization. It's a harmonization of European private laws in courts. It's very interesting for us to make some comparative study between codification in China and codification in Europe. We can make, and then we can find some very strange ideas, some not say very important conclusions. Firstly, how to use it? Firstly, I want to explain a legal term. What does it mean? Codification. Code. Code is a legal term came from the codex in Latin. In Latin, the codex means the tree of bark, the bark of the tree. In the Asian society, the person writes the document on his codex. So, in sense, in technical sense, the codex means systemization of all legal concept and institute in a legal document. And this, it does, but because please pay attention to the difference between the code and compilation. The famous 12-table law in Roman law is sometimes called, somebody calls codex. But the Justinian compilation in 60 countries of Greece is not a code. 12-table law we can call code, but Justinian compilation is not code because compilation is only the assembly of all different laws together. This is not code. French code, as we know, in development of codification, the history of codification of private law in Europe, we had a French code in 1804, and BGB is the German civil code in 19. There's their code, their civil code. Now, Europe is preparing its code. It's just undergoing some procedure called codification European private law. Probably it's not, as we know, because it's not something of our study now. Probably as we know, some European lawyers argue that it's necessary for Europe to adopt a unified civil code for whole Europe, especially Professor Christian Bombach. But the others say no, it's impossible to realize a civil code. We can just draft some principle, general principle that must be applied in different countries, member of the state of European Union. In this sense, the preparation of the drafting of the general principle of the city in the private law in Europe. It's not a codification. Codification just means that put all legal provisions of private law in a specific legal documents, codex. Now, let's study something about the history of the codification in law. Because, as Cicero said, the story, the history is the master of life. Historia magistra vitae is in Latin, very famous. So, if you want to, sorry, we just have some problem. Sorry. Just a moment, because it's different program of. Sorry. Is it because it is 2007? Okay, I don't know. In common, okay, just demonstration. The combination of legal rules in history of China began with Faji classical law, and this is law by a latest decree. It's a lawyer living in the 4th century before Christ. However, codification of civil law in sense of systematical elaboration of legal code dated back to a historical event called engraving the rulers of the punishment on Dings, like a wall. It's a cooking vessel in the Asian China, which was realized by the famous English Sun Yang, another lawyer living in the 4th century before Christ. After this event, almost all the Chinese emperor government began composing and enacting some written legal documents. And the principal part was called Li, in the feudal history of China, from the 4th century before, 3rd century before Christ to 1911. So China has the longest feudal history of society, history of feudal society. China, in Asian society, China legislature codified some criminal code or administrative code. It's just a melody of criminal code and administrative code. We haven't any civil code in the history of China. The reason for the absence of civil code in China are false. As follows. Here, some problem with PowerPoint. Sorry. How to use it? No. This one.
Yeah. Maybe.
Okay, it's okay. Okay. Good. Okay, no, we have some problem here. Okay, no, happening here. Okay. Sorry. 4 reasons for excellent civil code, existence of civil code in China are as follows. First, the strong influence of Confucianism in the Chinese history. The founder of Confucianism, Master Kongzi, the person living in the 6th century before Christ, believed that the basis of a stable, unified, enduring social order also be found in the religion dynasty Zhou. In its literature, he interprets the religion of dynasty Zhou as not as sacrifice, asking for the benefits and blessing of God, but as ceremony performed by human beings, and embodying the civilized and cultural pattern of behavior, developing through the generation of human wisdom. So, according to Confucius, a good society is not a society applying punishment. It's a good society. Everybody knows what he must do, what's the best behavior he must conduct. So, in the ethnic ruler plays more important ruler than the ruler of punishment. According to the famous interpretation by the famous philosopher Dong Zhongshu, is a person who was a philosopher living in 200 after Christ, second century after Christ. The literature called by Confucius means made of sevens of 3 gun and 5 charm. 3 gun means the 3 most important human relationships that between the ruler and his subjects, between the husband and his wife, between the father and his son. 5 gun. 5 gun means that most imbuing ethical rulers, that 仁义礼智信而和. Then means that benevolence, means right peace, is nature, sin is wisdom. But everybody, every individual must conduct his activity according to these 5 God, 5 most fundamental cardinal ruler of Africa. This is Confucian. So, in view of Confucian, the strict punishment of thief is not a good way to strive against the crime of theft. The best way to against the crime of theft is to teach everybody not to steal from others. So, in conformity with the speech of literature called for Confucius, the parties usually were encouraged to conciliate the dispute, resolve the dispute through a conciliation or arbitration by a third party whom both parties trust. The frequent settlement of dispute by means of conciliation arbitration gave many opportunities for application of customary law. So in traditional China, the civil law means the law governing civil relationship usually was in customary law. So the second reason for the absence of codification in China is it's caused by the pyramidal social structure. In China, in Asian China, it's like in the Asian law. The structure is almost the same thing. Every individual was born for the sake of his family. So the padre familia, the chief of the family, is the sole owner of the whole property of the family. And this chief of the father, padre familia, has the power to kill and punish all members of his family without any prior consent from the government. And then above is the family, there is clan. Clan is a group of family have the same ancestors. So the boss, the chief of the clan, has the same power of punishment against the chief of the family. And above the clan is mandarin. The mandarin usually was appointed by the emperor. Emperor is the last and the tallest figure stay in the pyramid of the social society. So in this pyramidal social structure, it's difficult to find room for protection of individuals. Another reason for the absence of codification in China, civil law, is the Chinese emperor applied the same economy policy of Adam Smith. According to the Chinese governor, only the agriculture activity can produce the property of the wealth. The businessmen, they earn money just by a trade. The commerce doesn't produce any property. So, for many centuries, China applied economic policy, so-called stimulus to the agriculture, suppression to the commerce. So, in this way, it's very difficult for the Chinese society to develop the economy and accommodating economy. So, as a result, the civil law is not so developed. The last reason for the absence of codification in the history of China, in the Asian society of China, is absence of a lawyer. In the absence of a lawyer, throughout of all the period of development of history of China, is also a very important reason for the lack of Chinese civil code. Because only in Rome, in Asian law, or also in Islam, for long history, we can find the real lawyer in the Asian history of the human being. Now let's study something about codification in China, in modern society. China was defeated by Japan in 1895. Many foreign countries, including Italy, invaded in China in 19 with the protest of put down of the Box Rebellion. China became a semi-feudal or semi-colonizer society. The last emperor of the dynasty Qin, probably you have seen the film called Last Emperor. It's a very famous film produced by an Italian famous regisseur Bertolucci. This is small. It's just in that period. He's just young boy. He thought that China must modernize his society, his social structure. He attempted to realize some legislative reform. In 1911, after 4 years' work, some Chinese lawyer finished preparing the first draft of Chinese civil law. Means the draft of the civil code, draft of the civil code of Great Dynasty Qin. This draft is composed by 1,569 articles, totally modeled upon the German civil code. on Japan's civil code. It's structured in this way. General part, obligation, real rights, family, and succession. But as you know, in 1912, the last emperor of China was kicked out from the Forbidden City, and China was governed by a nationalist party. The Republic of China was founded. The Republic of China also tried to codify a civil code, named for the German and Japanese lawyers. In 1925, the government of the Republic of China drafted its first draft of civil code. This draft used the same structure of the draft of the civil code of Great Dynasty Qing, but it contains more articles. It has about 1,745 articles. Due to the war, the civil war between the Chinese in that period, this draft civil code wasn't enacted, but the Chinese government invited the judges to cite the article provisions of this draft to motivate their judgment. And then in 1929, from 1929 and 1971, the nationalist party government of China succeeded on promulgation of the first civil code of China. It was called Civil Code Republic of China. It has exactly the same structure of German civil code. It contains 1,225 articles. So the first part is the general part, and obligation, real rights, also the family association. This is the structure. But as you know, in 1949, the Chinese Communist Party took over the power from the nationalist party and founded the People's Republic of China. And this civil code of the Republic of China was abolished in mainland China, but it is still valid in Taiwan, only in Taiwan. After the founding of the People's Republic of China, the Chinese Communist Party also tried to codify its civil code. But China passed some very difficult period for the lawyer, for the legal scholar. From 1949 to 1979, the Chinese government, the Communist Party government, asserted that the Communist Party was the pioneer of the all working class, worker class. So the law is the manifestation of the will of the dominating class. So in this way, the policy of the Chinese Communist Party must have the same function as a law. It's totally not necessary to make a law, because the policy of the Communist Party must work as a law. So in these 30 years, in China, there was nihilism of law. in this very difficult period for lawyers. Encouraged by and also suggested by some Chinese legal scholars, the Chinese government attempted twice to codify the civil law. First attempt was realized in 1956. The result is a draft of civil code with 500 articles. The 4 parts, general parts, are general parts, ownership, obligation, succession. Some political movement during 1946 to 1960 interrupt this first step towards codification. In 1972, under direct instruction of President Mao Zedong, the People's Republic of China attempted for the second time to prepare civil code. Completed in July 1964, the new draft was composed of 3 parts with only 252 articles: general provision, ownership, and transmission of property. This draft gave up almost all the use of any legal terms and was filled with only political slogans. This draft emphasized the duty of the citizen over their rights. Due to the Cultural Revolution from 1965 to 1975, this draft of civil code wasn't enacted. From 1979 to 1945, it was the spring of the development of Chinese law. In 1979, the political leader of China, Deng Xiaoping, visited for the first time the United States. He knelt the advanced modern technology of the United States, and he believed the modernization of China is based on modernization of technology. He thinks it's necessary, or not necessary, it's very urgent for China to introduce high technology from the foreign country. Immediately after his return in China, after visiting the United States, the legislature of China enacted the first civil law, first special civil law in July of 1979, joint venture law, with intention to attracting the international investment and introduce high technology to China. In this period, in this 6th year, also China realized with success its agricultural reform. In order to consolidate the result of the economic reform, the Chinese legislature began enacting many special laws to govern the civil relationship. So we have found marriage law, from 1980, and economic counter law of 1981. For economic counter law means the law of concept governing the relationship of concept between the Chinese legal subjects. Well, according to as far as the conceptual relationship concerning the foreign interest, we have another law. You can find law of concept concerning foreign interest in 1985. So in that period, the Chinese law, the Chinese civil law, was influenced strongly by the Soviet law, because the Soviet scholars think that the property law, the property relationship must be governed by two different laws. First is civil law, and then is economic law. What does mean economic law? Economic law means the law, administrative law governing the economic relationship. Civil law is only the law governing the different legal subjects with equal states. But that's very important. With equal state. So, in that period, there was a very sharp debate between the scholars on how to distinguish the economic law from the civil law. According to the civil law scholars, all property relationship must be governed by the civil law. But the proponent of economic law think totally different. They think any relationship regarding economic aspect must be governed by economic law. So this debate between the scholars add the impossibility to codify civil law, because it's difficult for a Chinese scholar in that period to understand well, clearly, what civil law is. But the Chinese literature adopt very pragmatic way to codify law. They try to only codify a special civil law, not civil code. So we have economic concern law, patent law, succession law, law of concern concerning foreign interests. In 1986, the Chinese legislature enacted very important fundamental civil law called General Principles of Civil Law. This is the mother law of all civil law in China. It contains only 156 articles, but it provides the basic general principle and legal institute of civil law. This general principle of civil law still remains the most important civil law in China. In China, as we know, after a while, there are many special civil laws, but all of the special civil law must have their validity or effective under this general principle of civil law. A general principle of civil law is considered fundamental law under the Constitution of the Republic of China. So if the provision in a special civil law is against to the general principle of civil law, this provision is invalid. So it's very important to remember it. The reason to enact this general principle of civil law instead of promulgation of civil code are as follows. First, China needed urgently a law government to govern the civil relationship in order to guarantee a legislative form the result of the economy reform. However, this economy reform wasn't complete. All civil code with detailed provision will risk future reform. So it's very problematic way. The second reason consists that the unprepared of the Chinese scholars, lawyers. In that period, the legal research and the teaching in China was very low level because of this about 20 years mechanism of law. So, in 1986, the Chinese legislature enacted these very important general principles of civil law. And then, at the same time, it continued enacting a different special civil law. So we have bankruptcy law, technology contract law, contract joint venture law, copyright law, adoption law. This is the law that most important special civil law enacted from 1986 to 1993. Something changed from the beginning of 1993 because in 1993, China modified its constitution and tried to carry out the policy of economy market, an abundant planned market economy. So, following this direction of change of economy policy, the Chinese legislature intensified the promulgation of the different special civil laws, especially the commercial laws. So from 1993 to 1999, we have company law, anti-unfair competition law, negotiable instrument law, insurance law, law of guarantee of obligations, law of partnership and enterprise, security law, also sole personal enterprise law. Now, I need to spend some words more on unification of law of contract in 1999. As I told you before, in China, before 1999, there were 3 different law of contract. Economic law of economic contract, which govern the contractual relationship between the Chinese legal subject. Law of contract concerning the foreign interest govern the contract relationship between the Chinese and the foreigners, or between the foreigners in China. And we also have the law of contract of technology, because according to Deng Xiaoping, the leader political, the technology is the most important thing. So the legislator adopt a special law of contract of technology. But as you know, it happened only in the planned economy period. To apply economy of market, it's important to respect equally all legal subjects, independently from his nationality. So, also it's necessary to recognize the freedom of contract. In this sense, the Chinese literature unifies these three different laws of contract and promulgated in 1999 a unified law of contract. This law is still invalid now. It's one of the most important special law, civil law in China. In 1999, China amended again its constitution and adopted the principle of rule of law. And China tried to become a member of the state of WTO. So, from 1999 to 2007, the Chinese literature modified many Chinese special civil law, especially, for example, marriage law, intellectual property law, company law. In particular, 2001, China enacted trust law. You know, trust is a totally legal institute of common law, following the experience of Japan, especially the experience of Japan. China also enacted trust law. In order to guarantee more the protection of workers, China legislature enacted also labor contract law. This is the first Chinese law to guarantee, Chinese civil law to guarantee the labor treatment of the workers. Especially, in particular, I must point out the drafting of the Civil Code in 2002. In December of 2002, some Chinese scholars thought it's the time for China to codify a civil code to guarantee the certainty of the law in China, because it's a huge country, it's so many population, and the education, legal education of the Chinese strategy was not so good. So in order to protect the individual rights, especially the result of reform of economy of market is necessary. It was necessary to codify a civil code, a civil law. So, in December of 2002, the Chinese Parliament prepared a draft of civil code. It contains 102,009 articles. It's divided into 9 parts. The first part is general part, real rights, and then real rights, contract, personality rights, marriage, adoption, succession, torts, obligation law of law in civil relations with foreigners. This is a very special draft because this draft is only a mechanical assembly of different special law. It's in technical sense or in strict sense, we cannot call it a civil code, a draft of civil code. Because the general part derived from the general principle of the civil code. Real rights, of course, is a special part prepared by a special committee of preparation of law of real rights. The part of the contract is totally the same thing of the law of the unified law of contract. Please pay attention to the personality right. This is typical Chinese invention because a Chinese legal scholar said that in a modern society, the law must protect more the personality rights. In German and French civil code and German civil code, the protection of the personality right was totally ignored. So we need to strengthen the protection of personality rights. So in this way, we create this special part, personality rights. The marriage is a totally contain the same provision of law of marriage. So the same thing happened to the adoption and succession, and also to the application of law in civil relations with foreigners. But we have a very special part, torts. Please pay attention to this fact. We have the general part of obligation. Why? According to the majority of Chinese law, the civil law scholar, the obligation in the modern civil law can arise from torts and contract. Unjust enrichment on the just negotiation are only exception. And this part, the provisions on the unjust enrichment and just negotiation can be provided in the general part. The latest civil code in the European continent, for example, the Hollandaise civil code, hasn't any general part of obligation. There's a property part, and the property part contains only the contract and the torts. It doesn't contain any general part of obligation. So according to this the Chinese civil law scholar, it's a modern tendency of development of the civil code in a modern society. without providing the civil, the general part of obligation. From 2007 till now, China enacted two very important special laws. One is law of real rights, with law of property. And then we have 2009 tort law. The plan now the Chinese legislature is planning to complete the promulgation, the drafting of the civil code within 6 years. The next step is try to enact a special law of personal rights, and then modify the general principle of the civil code and mandate it to become a general part of the civil code. And at last, finally, we can codify the civil code. This is the legislative plan. But as we know, in military, the current situation of civil law is in China is not so simple. Not only in China, the civil relationship in China isn't only governed by the special civil law or general principle civil law. There is a fragmentation of legal order on civil law. Besides general principle civil law and special laws, we have also many different provisions governing the civil relationship. First, the norms of civil law provide public law, particularly by the administrative regulations. For example, as to the protection of legal rights, it's not only to study the law of rights of 2007, but also you need also study the different administrative relations, rules, legislations, regulations. For example, we will study land administration law of 1986. Also, we have the law on urban real estate administration of 1994. The law on contracting of rural land, 2003. And the measures for chattel mortgage registration issued by the state administration office on commercial industry activity. So it's a very special situation in China. Besides the provisions governing the civil code, civil relationship, stipulated by the public law, we have also judicial interpretation. In China, the civil code has the power to interpret in abstract way the special law, also the general principle of civil law. This kind of judicial interpretation is abstract. It's not common on a single case or a judgment on a single case. This kind of interpretation produces binding effect for the judges in China. This is very special phenomenon in the world. For example, general principle of civil law has only 156 articles, but interpretation of Supreme Court on this law made in 1988 contains more than 200 articles. If you want to become a lawyer in China, you must study very well judicial interpretations. Because only these kind of interpretations are so concrete, can be applied to resolve a concrete dispute for a single case. Usually, the special law provisions in the special civil law are so general, so abstract, it's difficult to apply them to resolve, to find a legal solution for a single case. For example, another example is before the enactment of tort law in 2009, many solutions regarding torts were provided by the judicial interpretation from the Supreme Court. We have 1998 interpretation of the trial case concerning right of reputation. 2001 interpretation on emotional damage. 2001 interpretation on compensation for personal injury. All of them are the interpretation from the Supreme Court to govern the tort relationship. Besides abstract interpretation, the Chinese Supreme Court issues also directed opinions on single cases. For example, the most important, I will give you an example of concrete example. And in 2001, the Chinese Supreme Court gave a reply to the Superior Court, the Court of the Province of Shandong, for a case on education. The case, this case is very famous. It's called Qiyun case. What's the fact of this case? The case concerns a loss of opportunity to receive education in a busy school in Shandong province. For Miss Qiyun, this is a girl, name of a girl. She is a daughter of a farmer. After receiving a notice of Qiyun's admission to study at the busy school, the head of Qiyun's village, this is the head of the village where this girl living, and didn't deliver this notice of admission to this girl, but instead had his daughter study at the same business school, using the same name of the daughter of the farmer. 3 years later, this girl found she never sees an opportunity to study in university. And the daughter of the head of the village take her place. So this girl took legal action against the head of the village. But now there's a problem. What kind of right was violated? What kind of right of this girl, the daughter of the farmer, was violated? It's a problem. So the code of the superior code of province Shandong asked a question to the superior code. The superior code think that in this case the head of the village and the business school violate a citizen's right of receiving an education, which is a fundamental right protected by the Constitution law. So it's the first case to permit a Chinese judge to cite directly the provision of Constitution to protect a legal rights. And this case is very important. And the reply of the Superior Code on this case was applied to reserve analogous cases. But very strange. In 2008, on December 18, 2008, the Superior Code revoked this reply without any motivation. This decision by Superior Code provoked many debates among law experts. Some scholars argue that this revocation is correct because the Chinese Constitution doesn't allow any judge to cite its article directly to make decision. In contrast, the other belief in this decision serves as a mistake index for the Chinese ongoing judicial reform. Now China, for January 2011, from this year, the Chinese Supreme Court began a new system, this case governance system. According to this system, any judgment by the Supreme Court for a single case can be considered judgment for case governance. And the judges must apply the interpretation or the opinions of the Supreme Court to the analogous cases. This is very, very recent reform. It's now the center of debate among law experts in China. How to control this interpretation? How to know what's the criteria to apply the Supreme Court decision for similar cases? It's really a big question. It's not so easy to understand. Although here we have found also another many law modified in China in this period. So now, I want to conclude my lessons The characteristic of Chinese civil law, the Chinese current civil law, is like a solar system. The sun is the general principle of civil law. It's a fundamental law of civil law. Apparently, there are many different special laws of civil law or commercial law. Also, common starts their judicial interpretation for the Supreme Court. Sometimes also you can find judicial interpretation for the normal tribunal. In many cases, you can find also the code of province issue also interpretation, abstract interpretation. So it's a very, very special system. From the history of the codification of China, also undergoing codification of civil law in China, we can draw this following conclusion. The codification is just the result of a political view or decision. The Chinese legislature applied always pragmatical mentality. The problem in China is the central problem of codification of civil law in China is to study how to correct or control the deformed exercises of legislative power by Supreme Court administrative bodies. Please remember that in China we have a code of constitution. We have a constitutional code. So we have a body, public body, to guarantee or to interpret legitimacy of the law. Something probably is different in Europe. In Europe, the codification of private law or recodification of a single state member of European community is a result only from the struggle among different political groups or struggle among different countries. In China, situation is different. Only the Chinese Communist Party decide if it's necessary or not to codify civil code. We had this struggle between the different political groups. So the codification of civil code in China will be and will be result of political decision of the Chinese Communist Party. Also, we can find out that a good code in China, a good civil code in China, is based on good preparation of legal science. From 1979, China continued opening to the world. We sent many persons to study the law abroad. And many legal books in foreign language were translated into Chinese. It's very interesting for Chinese scholar to learn foreign experience of codification. For example, also the common code is very important. Also, the draft of common frame of reference are very important for the Chinese scholars. Now we are living in a period of modernization of law. the continental law and the common law are being mixed together. This phenomenon we can find is very easy in China. The Constitution in China is playing more and more important roles. We're in the globalization period, or we can find the food, the culture, also the race of the human being, all this mixed. So this mixture of different culture, I think is a good thing for development of human being. It's very good for development of human society. China now is in front of a very good situation. Means that we have a single code, so we can take advantage of all good things for the others. We can take something from Italy, from Italy, successful experience, something from France, from Germany, also from another society country, from Russia. China now is in a very good situation. The problem is that how to harmonize the law, and how much room is left for codification. As we know, today, the Constitution provides the general principle of civil rights. So in this sense, probably the general principle of the civil code in China loses some necessity. Because it's not, the Constitution provides the same thing. Codification, the civil code, can't provide complete all legal rules to govern the civil relationship. But it's important to have also a general principle. So for the European, now the European country is a period of recodification or decodification, resulting from the enactment of special laws in European countries. Also, you are also reading, you are realizing that civil codification is in European Union. All these periods is very interesting for us. We need install a continued exchange, dialogues between with the European countries, especially European, to learn many things from European experience of codification. Especially now we are living in this globalization period. There is also intercodification between diverse jurisdictions. We have more and more international treaties. We apply in many cases soft law, also international usage for the most important transaction of commerce, of trade in the world. We apply more international treaties or international usage. No, the law of a single country. So, but personally, I think for China now it's not so important to prepare a code or not. It's very urgent and very important for China to prepare highly educated law scholars. This is most important thing. Also, Europe can learn many things from the Chinese codification experience. This Chinese solar system is very flexible. It's very, especially many, as I know, many European private law scholars argue that it's important to only draft the general principle of private law for a state, for a single country of the European community. It's impossible to provide in detail the laws, the articles to regulate civil relationship for all countries of European. For example, I think the draft of common reference is useful for scholars. It's a result of doctrinal studies, but it's impossible to apply it for a European country. So, as we know, last things we learn some. We must remember that, as I write here in PowerPoint, we must always keep in mind law is prepared for the sake of all human beings. So only cause only use constitution as we are the human beings. We have the same idea. So in sometimes we have something in common, the law. I also must remember this very famous word, always vive ad nomine qui tribuere. I mean, what's the rule of law? The rule of law are three. Life with honesty, don't do harm to others. Everybody gets it belong, it due to him. It's law is only it's a science for good and equity. So keep in mind all these concepts. I think it's necessary, useful for us to study law. To conclude my presentation, I want to cite a very famous Chinese ancient poem. This is a poem written by a famous in the 100 after Christ. The article, the title is "Qi Lin." Firstly, I read it in Chinese and then I translate it into English. 横看成岭鹤成峰，远近高低各不同。不知庐山真面目，实身在此山中。横看成岭鹤成峰 means that read, view, horizontal became a peak if we view the same mountain vertical. Okay? 远近高低不同。The height of the mountain changed from the distance between us and it. So a very big mountain is very far. If it's very far, so we know it's very low. If a very small mountain, if we are so close to the mountain is so high. 不知庐山真面目 I don't know the real figure of mountain moon. 只缘身在此山中 because I'm inside this mountain. So the comparative study is extremely important. If you want to know better a law of a country, of your country, you must go outside from this country. You can know better. Thank you. Thank you for your attention.